landing on Legally Right, Legally Raven here. We're talking about worldwide Volkswagen v. Woodson. So, Mr. Justice White delivered this opinion to the court. The issue before us is whether, consistently with due process clause of the 14th Amendment, an Oklahoma court may exercise in-person jurisdiction over a non-resident automobile retailer, its wholesale distributor, in a products liability action when the defendant's only connection with Oklahoma is the fact that an automobile sold in New York to New York residents becomes involved in an accident in Oklahoma. Respondents Harry and Kay Robinson purchased a new Audi automobile from petitioner Seaway Volkswagen in Massena, New York in 1976. The following year, the Robinson family, who resided in New York, left the state for a new home in Arizona. As they passed through the state of Oklahoma, another car struck the Audi in the rear, causing a fire which severely burned Kay Robinson and her two children. The Robinsons subsequently brought a products liability action in the district court of the Creek County, Oklahoma, claiming that their injuries resulted from defective design and placement of Audi's gas tank and fuel system. They joined as defendants the automobiles manufacturer Audi, NSU Auto Union, its importer Volkswagen of America, its regional distributor Petitioner Worldwide Volkswagen Corporation, and its retail dealer petitioner Seaway. Seaway and Worldwide Web entered special appearances claiming that Oklahoma's exercise of jurisdiction over them would offend the limitation of the state's jurisdiction imposed by the Due Process Clause of the 14th Amendment. The facts presented in the district court presented that Worldwide was incorporated and had its business office in New York. It distributes vehicle parts and accessories under contract with Volkswagen to retailer dealers in New York, New Jersey, and Connecticut. Seaway, one of the retail dealers, is incorporated and has its place of business in New York. And so far as the record reveals, Seaway and the World Wide Web are fully dependent corporations whose relations with each other and with Volkswagen and Audi are contractual only. Respondents adduce no evidence that either Worldwide or Seaway does any business in Oklahoma, ships or sell any products to or in the state, has an agent to receive, process there, or processes advertisements in any media calculated to reach Oklahoma. In fact, as Respondents' Counsel conceded in oral argument, there was no showing that any automobile sold by Worldwide or Seaway has ever entered Oklahoma with a single exception of the vehicle involved in the present case. Despite the apparent paucity of contracts between the petitioner and Oklahoma, the district court rejected their constitutional claim and reaffirmed that ruling in denying petitioner's motion for reconsideration. Petitioners then sought a writ of prohibition in the Supreme Court of Oklahoma to restrain the district judge. Respondent Charles S. Woodson from exercising impersonal jurisdiction over them. They renewed their contention that because they had no minimal contacts with the state of Oklahoma, the actions of the district judge were in violation of their rights under the Due Process Clause. The Supreme Court of Oklahoma denied the writ, holding that personal jurisdiction over petitioners was authorized by Oklahoma's long-arm statute. Although the court noted that the proper approach was to test jurisdiction against both statutory and constitutional standards, its analysis did not distinguish these questions, probably because the Oklahoma statute had been interpreted as conferring jurisdiction to the limits permitted by the United States Constitution. The court's rationale was contained in the following paragraph. In the case before us, the product being sold and distributed by the petitioner is, by its very desired purpose, so bold that petitioners can proceed as possible use of Oklahoma. This is especially true to the distributor, who had the exclusive right to distribute such automobile in New York, New Jersey, and Connecticut. The evidence presented below demonstrated that goods sold and distributed by the petitioners were used in the state of Oklahoma, and under the facts, we believe it's reasonable to infer, given the retail value of the automobile, that the petitioners derive substantial income from automobiles, which from time to time are used in the state of Oklahoma. This being the case, we hold that under the facts presented, the trial court was justified in concluding the petitioners derive substantial revenue from goods used or consumed in the state. We granted, how do you pronounce this? Certiorari to consider an important constitutional question, with respect to state court jurisdiction and how to resolve conflict between the Supreme Court of Oklahoma and the highest courts of at least 4 other states. We reverse. certiorari, a writ order of a higher court to a lower court to send all the documents in the case to it so the higher court can review the lower court's decision. Certiorari, certiorari. Okay, so we know. The Due Process Clause of the 14th Amendment limits the power of the state court to render a valid personal judgment against a non-resident defendant. A judgment rendered in violation of due process is void in being a judgment rendered in violation of due process is void in the rendering state and is not entitled to full faith and credit elsewhere. Penoyer v. Neff, 95 U.S. 714, 732 to 33, 1878. Due process requires that the defendant be given adequate notice of the suit and be subject to the personal jurisdiction of the court. International Shoe Company v. Washington, 326 U.S. 310, 1945. In the present case, it is not contended that notice was inadequate. The only question is whether these particular petitioners were subject to the jurisdiction of the Oklahoma courts. As long been settled, and as we affirm today, a state court may exercise personal jurisdiction over a non-resident defendant only so long as there exists minimum contact between the defendant and the forum state. International Shoe 326 U.S. at 316, the concept of minimum context in time can be seen to perform two related but distinguishable functions. It protects the defendant against the burdens of litigating in a distant or inconvenient form, and it acts to ensure that the state, through their courts, do not reach beyond the limits imposed on them by their statutes as co-equal sovereigns in a federal system. So the states are not equal. They are not co-equal sovereigns. The protection against inconvenient litigation is typically described in terms of reasonableness or fairness. We have said that the defendant's contacts with the forum state must be such that maintenance of the suit does not offend traditional notions of fair play and substantial justice. International Shoe 326 U.S. 316, quoting Milliken v. Meyer 311 U.S. 457 463 1940. The relationship between the defendant and the forum must be such that it is reasonable to require the corporation to defend a particular suit which is brought there. 326 U.S. 317, implicit in the emphasis on reasonableness is the understanding that the burden on the defendant, while always a primary concern, will in an appropriate case be considered in light of other relevant factors, including the forum state's interest in adjudicating the dispute. See McGee v. International Life Insurance Company. The plaintiff's interest in obtaining convenient and effective relief, at least when the interest is not adequately protected by the plaintiff's power to choose the forum. The interstate judicial system's interest in obtaining the most efficient resolution of controversies and the shared interest of the several statutes in furthering fundamental substantive social policies. The limits imposed on state jurisdiction by the Due Process Clause in its role as the guarantor against inconvenient litigation has been substantially relaxed over the year. As we noticed in McGee, the trend is largely attributable to a fundamental transformation in the American economy. Today, many commercial transactions touch two or more states and may involve parties separated by the full continent. With this increasing nationalization of commerce has come a great increase in the amount of business conducted by mail across state lines. At the same time, modern transportation and communication have made it much less burdensome for a party sued to defend himself in a state where he engages in economic activity. The historical developments noted in McGee, of course, have only accelerated in the generation since the case was decided. Nevertheless, we have never accepted the proposition that state lines are irrelevant for jurisdictional purposes, nor could we, and remain faithful to the principles of interstate federalism embodied in the Constitution. The economic interdependence of the states was foreseen and desired by the framers, the Commerce Clause. They provided that the nation has to be a common market, a free trade unit in which the states are debarred from acting as separable economic entities. But the farmers also intended that the states retain many essential attributes of sovereignty, including in particular the sovereign power to try cases in their courts. The sovereignty of each state in turn implied a limitation on the sovereignty of all the sister states, a limitation expressed or implicit in both the original scheme of the Constitution and the 14th Amendment. Hence, while abandoning the shibboleth that the majority of every tribunal is necessarily restricted by the territorial limits of the states in which it established. Pennoyer 95 U.S. at 720, we emphasize that the reasonableness of asserting jurisdiction over the defendant must be assessed in the context of our federal system of government, international shoe, and stress that due process clause ensures not only fairness, but also orderly administration of laws. How do you pronounce this and what does it mean? Custom principle distinguishing a particular class or group of people. Shibboleth. The majority, under the influence of vague 19th century shibboleths, understood him to be associating himself with the doctrine that every nation has the right to be a sovereign state. A custom principle or belief distinguishing a particular class or group of people, especially a long-standing one, regarded as outmoded or no longer important. Shibboleth. Okay. Hence, even while abandoning the shibboleth, outdated or unimportant idea that's held by a group of people that the authority of every tribunal is necessarily restricted by the territorial limits of the states and which is established, Pennoyer 95 U.S. at 720, we emphasize that the reasonableness of asserting jurisdiction over the defendant must be assessed in the context of our federal system of government. International Street 326 U.S. at 317, and stressing the due process clause ensures not only fairness, but also the orderly administration of laws, as we noted in Hansen. As technological process has increased the flow of commerce between the states, the need for jurisdiction over non-residents has undergone a similar increase. At the same time, progress in communication and transportation has made the defense of a suit in a foreign tribunal less burdensome. In response to these changes, the requirements of personal jurisdiction over non-residents has evolved from the rigid rule in Pennoyer to the flexible standard of international shoe, but it is a mistake to assume that the trend heralds the eventual demise of all restrictions on the personal jurisdiction of state courts. These restrictions are more than a guarantee of immunity in inconvenient or distant litigation. They are consequences of the territorial limitation of the power of the respective states. So just because it's evolving and transportation is getting easier and mobile and communication is getting easier, still the territorial limitations of respective rights they have states. So personal jurisdiction of the state court will never go completely away, according to this. Thus, the due process clause does not contemplate that a state may have binding a judgment in person against an individual or corporate defendant with which the state has no context, ties, or relations. International Street 326. Even if the defendant would suffer minimum or no inconvenience from being forced to litigate before the tribunals of another state, even if the forum state has long interest in applying its law to the controversy, even if the forum state is the most convenient location for litigation, the due process clause, acting as an instrument of interstate federalism, may sometimes act to divest the state of its power to render a valid judgment. Does not contemplate that a state making a binding Okay, so even if all the reasons say, hey, this is the most convenient court, the due process clause, acting as an instrument of interstate federalism, may sometimes act to divest the state of its power to render a valid judgment. Okay, so applying these principles to the case here, we find in the record before us a total absence of those affiliating circumstances that are necessary to predicate to any exercise of state court jurisdiction. Petitioners carry on no activity whatsoever in Oklahoma. They close no sales and perform no services there. They avail themselves to none of the privileges and the benefits of Oklahoma law. They solicit no business there, either through salespersons or through advertising reasonably calculated to reach the state. Nor does the record show that they regularly sell cars at wholesale or retail to Oklahoma customers or residents, or that they indirectly through others serve to seek or to serve or seek to serve the Oklahoma market. In short, respondents seek to base jurisdiction on one isolated occurrence, and whatever inference can be drawn from the fortuitous circumstances that a single Audi automobile sold in New York to New York residents happened to suffer an accident while passing through Oklahoma. So, yeah, they don't have any activity in Oklahoma, and they're trying to say that this circumstance happened, true, but it's like it just so happened to happen when passing through Oklahoma. Okay. They argue, however, that because an automobile is by its very design and purpose, it was foreseeable that the Robinsons Audi would cause injury to Oklahoma. Yes, foreseeability alone has never been a sufficient benchmark for personal jurisdiction under the Due Process Clause. So, in Hansen v. Dinkla Supra, what does this mean? Let me just go ahead and look it up now because I've seen it a lot of times and I never look it up. Supra, Latin for above. In legal briefs and decision, it refers to the citation of the court decision, which has been previously mentioned. Supra, okay, above. In legal briefs, the decision, it refers to the citation of a court decision that has been previously mentioned. Okay. In Hansen v. Decla Supra, it is no doubt foreseeable that the settler of a Delaware trust would subsequently move to Florida and seek to exercise power of appointment there. Yet we held that Florida courts could not constitutionally exercise jurisdiction over a Delaware trustee that had no other context with the form state. In Kuklo v. California Superior Court in 1978, it was surely foreseeable that a divorced wife could move to California from New York, the domicile of the marriage, and that a minor daughter would live with the mother. Yet we held that California could not exercise jurisdiction in a child support action over the former husband who remained in New York. If foreseeability were the criterion, a local California tire dealer could be forced to defend in Pennsylvania when a blowout occurs there. A Wisconsin seller of defective automobile jack could be held before a distant court in damage caused in New Jersey. A Florida soft drink concessionaire could be summoned to Alaska to account for injuries happening there. Every seller of chattel would, in effect, appoint the chattel his agent for service of process. His ability to sue would travel with the chattel. This is not to say, of course, that foreseeability is wholly irrelevant, but foreseeability that is critical to due process analysis is not the mere likelihood that a product will find its way into the form state. Rather, it is that the defendant's conduct in connection with the form state are such that he should reasonably anticipate being held into court there. The due process clause by ensuring the orderly administration of laws. International Shoe gives a degree of predictability to the legal system that allows potential defendants to structure their primary conduct with some minimum assurance as to where the conduct will and will not render them liable to a suit. Because remember, International Shoe, they'd actually hire salespeople to live in Washington State. When a corporation purposefully avails itself to the privilege of conducting activities within the form state, Hansen 357 U.S. at 253, it has clear evidence that it is subject to suit there, and it can alleviate the risk of burdensome litigation by producing insurance, passing the expected cost on to customers, or if the risks are too great, severing its connection with the state. Hence, if the sale of products of a manufacturer or distributor such as Audi or Volkswagen is not simply an isolated occurrence, but arises from the efforts of the manufacturer or distributor to sever directly or indirectly the market for its products in other states, it is not unreasonable to subject it to suit in one of those states if its allegedly defective merchandise has been the source of injury to its owner or to others. The forum state does not exceed its powers under the due process clause. If it asserts personal jurisdiction over a corporation that delivers its products to the stream of commerce with the expectation that they will be purchased by consumers in the forum state. That's from American Radiator. So, hence, if the sale of a product or manufacturer such as Audi Volkswagen is not simply isolated occurrence but arises from the efforts of men to distribute and serve directly then indirectly the market product of the states, it is not unreasonable to substitute in those states if allegedly defective market accidents occur. So if you're actively trying to sell something somewhere, then it should be reasonable that something can happen there. So it can't just be that I sold it over here to a person who lives here and they drive it anywhere they want to. I mean, you could take it to Mars and then you could have an issue. And then what would we do? The forum state does not exceed its powers under the due process clause if it asserts personal jurisdiction over a corporation that delivers its products into the stream of commerce with the expectation that it will be purchased by consumers in the forum state. And that's from Gravy American Radiator. I remember that. But there is no such or similar basis for an Oklahoma jurisdiction over worldwide or Seaway in this case. Seaway sales are made in Massena, New York. Worldwide's market, although substantially larger, is limited to dealers in New York, New Jersey, and Connecticut. There is no evidence of record that any automobiles distributed by Worldwide are sold to retail customers outside the tri-state area. It is foreseeable that the purchasers of automobiles sold by Worldwide and Seaway make them to Oklahoma, but the mere unilateral activity of those who claim some relationship with a non-resident defendant cannot satisfy the requirements of contacts with the forum state. In a variant on the previous argument, it is contended that jurisdiction can be supported by the fact that petitioners earn substantial revenue from goods used in Oklahoma. The Oklahoma Supreme Court so found, drawing an inference because one automobile sold by petitioner had been used in Oklahoma, others might have been used there also. While the inference seems less than compelling on the facts in the instant case, we need not question the court's factual findings in order to reject its reasoning. The argument seems to make the point that the purchase of automobiles in New York, from which the petitioners earn substantial revenue, would not occur but for the fact that automobiles are capable and used like distant states of Oklahoma. All right. So they're saying that people wouldn't buy cars in New York if they couldn't be used to travel to distant states like Oklahoma. Respondents observe that the very purpose of the automobile is to travel, and that the travel of automobiles sold by petitioners is facilitated by an extensive chain of Volkswagen service centers throughout the country, including some in Oklahoma. However, financial benefit occurring from the defendant from a collateral relationship in the formal state will not support jurisdiction if they do not stem from a constitutionally cognizable contact with the state. In our view, whatever marginal revenues petitioner may receive by virtue of the fact that their products are capable of use in Oklahoma is far too attuned to contact to justify the state's exercise of impersonal jurisdiction over them. Because we find that petitioners have no context ties of relation with the state of Oklahoma, the judgment of the Supreme Court of Oklahoma is reversed. Mr. Justice Brennan dissenting, because I believe that the court reads international shoe and is progeny too merely, and because I believe that the standards enunciated by those cases may already be obsolete as constitutional boundaries, I dissent. The court opinions focus lightly on the existence of context between the forum and the defendant. In doing so, they accord too little weight to the strength of the forum state's interest in the case and fail to explore whether there would be any actual inconvenience to the defendant. The essential injury in locating the constitutional limits on the state court's jurisdiction above absent defendants is whether the particular exercise of jurisdiction offends traditional notions of fair play and substantial justice. The clear focus in international shoe was on fairness and reasonableness. The court specifically declined to establish a mechanical test based on the quantum of context between the state and the defendant. So was it unfair, wasn't unreasonable for them to get the litigation in Oklahoma? Whether due process is satisfied must depend rather upon the quality and nature of the activity in relation to fair and orderly administration of laws, which it was the purpose of the due process clause to ensure. The clause does not contemplate that a state may make binding a judgment in personam against an individual or a corporate defendant with which the state has no context, ties, or relations. Whether due process is satisfied must depend rather upon the quality and nature of the activity in relation to the fair and order administration of law, the purpose of due process clause to ensure. The existence of a context, so long as there were some, was merely one way of giving content to the determination of fairness and reasonableness. Surely, International Shoe contemplated that the significance of the context necessary to support jurisdiction would diminish if some other consideration helped establish the jurisdiction would be fair and reasonable. The interests of the state and other parties in proceeding with the case, in particular, in a particular form, are also considerations. McGee, for instance, accorded a great importance to the state's manifest interest in providing effective means of redress for citizens. So it's not just about, they talked about the significance of context necessary to support jurisdiction would diminish if some other consideration had helped establish the jurisdiction would be fair and reasonable. So my question, I guess, is what other, this Justice Brennan, what other considerations would have made this fair and reasonable? Another consideration is the actual burden a defendant must bear in defending the suit in the forum. McGee, circular, because lesser burdens reduce the unfairness of the defendant, jurisdiction may be justified despite less significant context. The burden, of course, must be of constitutional dimension. Due process limits on jurisdiction do not protect the defendant from all inconvenience of travel, and it would not be sensible to make the constitutional rule turn solely on the number of miles the defendant has to travel to the courtroom. Instead, the constitutionally significant burden to be analyzed relates to the mobility of the defendant's defense. For instance, if having to travel to a foreign forum would hamper the defense because witnesses or evidence of the defendant himself were immobile, or if there were a disproportionately large number of witnesses or amount of evidence that would have to be transported at the defendant's expense, or being away from the home for the duration of the trial work, would work some special hardship on the defendant, then the Constitution will require special consideration for the defendant's interest. That considerations other than the context between the forum and the defendant are relevant. Okay. That considerations other than the context between the forum and the defendant are relevant necessarily means that the Constitution does not require the trial to be held in the state which has the best context for the defendant. The defendant has no constitutional entitlement to the best forum, or for that matter, to any particular forum. Under even the most restrictive view of International Shoe, several states could have jurisdiction over a particular cause of action. We need only determine whether the forum states in these cases satisfy the constitutional minimum. That considerations other than context between the forum state and the defendant are relevant necessarily means that the Constitution does not require that trial be held in the state which has the best context for the defendant. The defendant has no constitutional entitlement to the best forum, or for that matter, to any particular forum. Under even the most restrictive view of International Shoe, several states could have jurisdiction over a particular cause of action. We need only determine whether the forum state in the case satisfies the constitutional minimum. That's interesting. So it doesn't have to be, the trial doesn't have to be held in the state that has the best context with the defendant. That's not what this is about. So it's not like you line them up and you're like, oh, okay, they have the most minimum context here or the best minimum, and that's the one we go with. Several states can have jurisdiction over a particular cause of action. So we only need to determine whether this forum state satisfies the constitutional minimum, and any of the forum states that satisfy the constitutional minimum could be forum states. The states themselves, of course, remain free to choose whether to extend their jurisdiction to embrace all defendants over whom the Constitution would permit to exercise jurisdiction. So the state can choose whether to extend their jurisdiction to embrace all the defendants whom the Constitution would permit exercise of jurisdiction. I would find that the forum state has an interest in permitting the litigation to go forward. The litigation is connected to the forum. The defendant is linked to the forum, and the burden of defending is not unreasonable. Accordingly, I will hold that neither unfair nor unreasonable to require these defendants to defend in the forum state. The interest of the forum state and its connection to litigation is strong. The automobile accident underlying the litigation occurred in Oklahoma. The plaintiffs were hospitalized in Oklahoma when the suit was brought. Essential witnesses and evidence were in Oklahoma. The state has a legitimate interest in enforcing its laws designed to keep the highway system safe. And the trial can proceed at least as efficiently in Oklahoma as anywhere else. The petitioners are not unconnected to the forum, although both sell automobiles within limited state territories. Each sold the automobile, which in fact was driven to Oklahoma, where it was involved in the accident. It may be true, as the court suggests, that they sincerely intended to limit its commercial impact to the limited territory, and that each intended to accept the benefits and protection of the laws only in the states within the territory. But obviously, these were unrealistic hopes that cannot be treated as an automatic constitutional shield. On the basis of the fact that the state court inferred that the petitioners derived substantial revenue from goods used in Oklahoma, the inference was not without support. Certainly were use of goods accepted as a relevant contact, a plaintiff would not need to have an exact amount of number of petitioner cars that were used in Oklahoma. Certainly were the use of goods accepted, the plaintiff would not need to have an exact count of a number of petitioner cars that were used in Oklahoma. Moreover, imposing liability in this case would not so undermine certainty as to destroy an automobiler's ability to do business. According jurisdiction does not expand liability except in a marginal case where a plaintiff cannot afford to bring an action except in the plaintiff's own state. In addition, these petitioners are represented by insurance companies. They not only could but did purchase insurance to protect them should they stand trial in this case. The cost of the insurance, no doubt, are passed on to customers. I represent they not only could but did purchase insurance to protect themselves should they stand trial and lose the case. And so they hope that the cars will be used in a limited territory, but you can't use that as a constitutional shield. An automobile simply is not a stationary item or one designed to be used in one place. An automobile is intended to be moved around. Someone in the business of selling large numbers of automobiles can hardly plead ignorance to their mobility or pretend the automobiles stay put after they are sold. It is not merely that a dealer in automobiles foresee that the dealer actually intends that the purchaser will use the automobile to travel to distant states where the dealer does not directly do business. The state of an automobile does purposefully inject the vehicle into the stream of interstate commerce so that it can travel to distant states. This case is similar to Ohio v. Wyandotte Chemical Corporation. There we indicated in the course of denying leave to file an original jurisdiction case that corporations having no direct contact with Ohio could constitutionally be brought to trial in Ohio because they dump pollutants into streams outside Ohio's limits, which ultimately, through action of water, reached Lake Erie and affected Ohio. No corporate acts, only their consequences occurred in Ohio. The stream of commerce is just as natural as a force of a stream of water, and it equally predictable that cars petitioners' release would reach distant states. One might argue that it was more predictable that the balloons would reach Ohio than the one petitioner's car would reach Oklahoma. The court's analysis, however, excludes jurisdiction in a contiguous state such as Pennsylvania, that surely is in more distant states as Oklahoma. Right. Oh, so their decision is saying like, oh, the decision means that you, it would say Pennsylvania doesn't have quorum, just like it's saying that the courts now discover excludes jurisdiction in a contiguous state such as Pennsylvania. Assuredly, it's more distant states like Oklahoma. So that's the problem. It is very foreseeable that somebody in the tri-state area of New York, New Jersey, Connecticut would go to Pennsylvania because it's contiguous. But the way that this decision read is saying, well, no, they don't have they because they didn't do or seek to do business in that state, that they wouldn't have the Pennsylvania courts would not have jurisdiction there either. In each case, the seller purposely inducts goods into the stream of commerce, and the goods predictably are used in the foreign state. Furthermore, an automobile seller derives substantial benefit from states other than its own. A large part of the value of automobiles is the extensive nationwide network of highways. Significant portions of that network have been constructed by and are maintained by the individual states, including Oklahoma. The states, through their highway programs, contribute to a very direct and important way to the value of the petitioner's business. Additionally, a network of other related dealerships with their service departments operates throughout the country under the protection of the laws of various states, including Oklahoma, and enhances the value of the petitioner's business by facilitating their customers' travel. So you have the highway network, and then also the network of service centers. Thus, the court errs in its conclusion that petitioners have no context ties or relations with Oklahoma. There obviously are contexts, and given Oklahoma's connection to the litigation, the contexts are sufficiently significant to make fair and reasonable for the petitioners to submit to Oklahoma's jurisdiction. International Shoe inherited its defendant focus from Panayir v. North and represented the last major step this court has taken in the process of liberalizing the doctrine of personal jurisdiction. Through its flexible approach, represented a major, though its flexible approach represented a major advance. The structure of our society has changed in many significant ways since International Shoe was decided in 1945. Mr. Justice Black, writing for the court in McGee, recognized that a trend is clearly discernible toward expanding the permissible scope of state jurisdiction over foreign corporations and other non-residents. He explained the trends as follows. In part, this is attributable to the fundamental transportation of our national economy over the years. Today, many commercial transactions touch two or more states and may involve parties separated by the full continent. With this increasing nationalization of commerce, has come a great increase in the amount of business conducted by mail across state lines. At the same time, modern transportation and communication have made it much less burdensome for a party to be sued and to defend himself in a state where he engages in economic activity. So, first of all, commerce is becoming national, and second of all, technology is allowing it not to be a hardship to defend in a different state. As the court acknowledges, both nationalization and commerce and the ease of transportation and communication have accelerated in the generation since 1957. The model of society on which International Shoe Court bases opinion is no longer accurate. Business people, no matter how local their business, cannot assume that goods remain in their business locality. Customers and goods can be anywhere else in the country, usually in a matter of hours, and always in a matter of in a very few days. And answering the question whether or not it is fair and reasonable to allow a particular forum to hold a trial binding on a particular defendant, the entrance of the forum state and other parties loom large in today's world and surely are entitled to as much weight as the interest of the defendant. The orderly administration of laws provides a firm basis for according some protection of the interests of the plaintiffs and states as well as defendants. Certainly, I cannot see how a defendant's right to due process is violated if the defendant suffers no inconvenience. The conclusion I draw is that constitutional concepts of fairness no longer require the extreme concern for defendants that was once necessary. Rather, as I wrote in dissent of Schaefer v. Heitner, 433 U.S. at 220, emphasis added, minimum context must exist among the parties. The contested transaction, and the forum state. The context between two of these should not be determinative or determinative. The context between two of these should not be determinative. When a suitor seeks to lodge a suit in a state with a substantial interest in seeing its own law applied to the transaction in question, we could wisely act to minimize conflicts, confusion, and uncertainty by adopting a liberal view of jurisdiction, unless considerations of fairness or efficiency strongly point in the opposite direction. Such a standard need be no more uncertain than the court's test, in which few answers will be written in black and white. The grays are dominant, and even among them, the shades are innumerable. Mr. Justice Black, dissenting in Hanson, expressed similar concerns by suggesting that a state should have jurisdiction over a case growing out of a transaction significantly related to the state, unless litigation there would impose such a heavy and disproportionate burden on a non-resident defendant that it would offend what this court has referred to as traditional notions of fair play and substantial justice. Assuming that a state gives a non-resident defendant adequate notice and opportunity to defend, I do think the due process clause is offended merely because the defendant has to board a plane. I do not think the due process clause is defended just because the defendant has to board a plane to get to the site of the trial. The court's opinion suggests that the defendant ought to be subject to a state's jurisdiction only if he has contacts with the state, such as that he should reasonably anticipate being held to court there. The court suggests that this is the critical foreseeability rather than the likelihood that the product will go into the forum state. But the reasoning begs the question: a defendant cannot know if his actions will subject him to jurisdiction in another state until we have declared what the law, his actions will subject him to jurisdiction in another state until we have declared what the law of jurisdiction is. So if the law of jurisdiction is declared, then they can't foresee whether or not their actions will take them to another court, into another forum state. There is nothing unreasonable or unfair, however, about recognizing commercial reality. Given the tremendous mobility of goods and people, the inability of businessmen to control where goods are taken by customers or retailers, I do not think that the defendant should be in complete control of the geographic stretch of his amenability to suit. Jurisdiction is no longer premised on the notion that non-resident defendants have somehow implied consented to suit. Jurisdiction is no longer premised on the notion that non-resident defendants have somehow implied consented to suit. People should understand that they are held responsible for the consequences of their actions, and that in our society, most actions have consequences affecting many states. When an action in fact causes injury in another state, the actor should be prepared to answer for it, unless defending in that state would be unfair for some reason other than the state boundary must be crossed. In effect, the court is allowing defendants to assert the sovereign rights of their home states. The expressed fear is that otherwise all limits on personal jurisdiction would disappear. But the argument's premise is wrong. I would not abolish limits on jurisdiction or strip state boundaries of all significance. I would still require the plaintiff to demonstrate sufficient contracts among the parties, the forum, and the litigation to make the forum a reasonable state in which to hold a trial. I would also, however, strip the defendant of the unjustified veto power over certain very appropriate for a power the defendant justifiably enjoyed long ago when communication and travel over long distances were slow and unpredictable, and when notions of state sovereignty were impractical and exaggerated. But I repeat that is not today's world. If a plaintiff can show that his chosen forum state has sufficient interest in his litigation or sufficient context with the defendant, then the defendant who cannot show some real injury to the constitutionality protected interest should have no constitutional excuse not to appear. Frequently, of course, the defendant will be able to influence the choice of the forum through traditional doctrines such as venue or forum not convenient, permitting the transfer of litigation. All right, and that is the case. So this is, let's go back to the beginning. This is Worldwide Volkswagen v. Woodson. In the next video, we will go over notes and questions for understanding Worldwide Volkswagen. Thank you for tuning in this morning to Legally Married, Legally Raven Haired.